Hey y'all, hope everybody's doing okay. But we're going to get into our reaction, okay? In a Friday, October 13 hearing, Florida Circuit Judge John Murphy recused Broward County Assistant State Attorney Christine Bradley from the case of YNW Melly. So my title said YNW Melly trial. Judge removing lead prosecutor from Melly trial. Created 22 witnesses. Okay. The ruling represents a half victory for the Melly's defense team, whose motion to recruit include not only Braley, but the entire Broward County State Attorney Office. With judge selection for the double murder trial still scheduled to start Monday, y'all. It's going to start tomorrow, okay? So y'all look out for it on October the 16th, which is going to be, when you hear this video, it's going to be today. So that's going to be tomorrow. The judge asked the prosecution to swear in a new lead prosecutor to the case quickly, as the South Florida Sun Sentinel notes. The decision effectively rules out the defense hopes of getting the case dismissed before the trial began, although Judge Murphy has not officially ruled out their motion to dismiss as of yet, despite despite the 13 outstanding motions to suppress evidence collectively uh, filed by both sides the week before last, as well as more than 30 newer motion filed by the defense, among their requests to add more attorneys to their team. The judge said no that the official trial will begin on Monday as planned, but that the court would set aside Fridays to hear arguments on all outstanding motions. The fader has reached out to the Broward County State Attorney Office and to YNW Meta Defense Team for further comments on their ruling. Okay. All right, y'all. Let's get into this now. I hope everything come out right Monday, where they won't let the defense try to run the court. Okay.
Conducts itself in a way as to ambush there, not to get the benefit of that. These trials, we understand, the notion that the state comes here and asks jurors to put somebody to death suggests that they have completed an investigation that warrants that co-signature. To suggest that, okay, there are a lot of things that we could have done and we didn't do, and if you ask about them, we're going to go do it and introduce it while the proceedings ensue, is not only an ambush, but it's an insult to the process. They're saying that they have the evidence. Now, the state can get up there and say, hey, the defense is making some ridiculous cross-examination and we don't have everything because what we have is enough, which is when they bring an indictment of this nature, of any indictment, they're saying we have enough now, beyond a reasonable doubt. But what they cannot do is, as these proceedings go forward, continue to investigate and plug holes that we reveal to exist as the process goes on until this case goes to verdict. I'm not quite sure when this would end or how there is even a gatekeeping function of the court if there is no gate and there is no fence and there are no lines and no parameters.
I was able to trade this coin from Carvana for a brand new car. Here's how.
The state is making a representation by bringing this indictment. And if that proof beyond a reasonable doubt also includes areas of investigation that were not pursued, then they should explain to a jury why it was not pursued and why the failure to pursue it does not undermine their case. They don't get to keep plugging holes as the proceedings go forward. And so, as the Fourth Circuit said, that is ambush. And the purpose of, the Fourth DCA said that is ambush. And the purpose of a discovery deadline is to avoid surprise, avoid ambush, and a party that engages in that ought not to get the benefit of it.
Thank you.
Thank you.
Hold on.
Just briefly, you mentioned that defense hasn't yet to provide any reciprocal discovery, but alluded to some yesterday that they were looking at Instagram posts and everything that had happened as recently as this week, but yet they have provided nothing to the state.
The judge been so rude. Look at him. He's not even looking at her.
Thank you. Oh, Counsel, my understanding is that's the way it works, is that it's not RECUSED violations apply to both sides, but it's probably just one side. It's deadlines apply to both sides. And there's a obligation, that's not what it's all about.
I apologize. The printers decided to not work. I'm sorry.
I apologize. What I was saying is that the whatever obligations that are imposed would be applicable to both sides when the discovery cutoff or not. My thought is as to the discovery cutoff, you can keep investigating the case, however you feel fit, and you're more than welcome to do that. However, that doesn't mean that anything you find can be used at trial as in evidence. This thing with Mr. Goretti, where when I'm out of town on vacation, you're asking the detective what he's offering. I'm not really sure how it happened to continue and run this through another process. And the defense doesn't know about it. The defense cross-examines Mr. Zellner, or Officer Zellner, and is not aware that he's asking questions.
And even look at her.
Other programs, his understanding is there isn't any other program. But you know there's another program, they have access to it, and they've done it. You just don't have the results. That seems to me to be what the council's talking about. And it seems to me to be a RECUSED violation. There's discovery that's ongoing, you know about it, and you're not telling them about it until we're here in court. So as far as I'm already is concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. I just think the only way it can be cured is he's not going to testify about this second procedure that happened. That's not coming in. Same thing. If you want to keep investigating the case, you can do it. You can find exculpatory information. You may change your mind as to how you proceed with the case, and I don't have a problem. You can investigate whatever you want to investigate. But as far as using new discovery that you're coming in, I think a cutoff needs to be happened because this is what's going on. We're going to have.
Really, to be honest with you, when they call our name, when they gave us numbers here in Georgia, they don't call us by name. They call us by numbers. They said number 48, 52, and stuff like that. But what they want to do is call people name out. So when they call your name out, they'll know if they recognize you or not. You know what I mean? Like, oh, that's Robert. Yeah. That's no, man. We can't have him. You know what I mean? You're supposed to go by numbers instead of names. So I can understand what the prosecutor said, but they don't want to use numbers. They want to use names.
And you try to find evidence to plug up the hole that's new discovery. You know, the defense doesn't have an opportunity to depose the witness. The defense doesn't have an opportunity to do X, Y, and Z. And that's just not the way it should be. It shouldn't be done by surprise. So
it's clear this was not a new item. This was just this, all of the information was supposed to be identical.
you found it, you had a meeting with the detective in May when we're in hiatus because I'm on vacation. All right, you had a meeting with him in May after we picked a jury, and when we're ready to, or we're in the middle of jury selection, you picked it, you did it, and you said, well, he tells you, or you ask him, do you have more programs to go ahead and provide the information, and you find out there's another program, and he runs the program, does a different download with something other than Cellbrite, and therefore, you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple weeks of trial testimony, and then when it comes up after he, in cross-examination, points something out, you bring it up and say, well, by the way, I told him, the detective in our pretrial meeting, it came up and he has the program and we can use it and we're doing it. All right. And, but you don't tell him about it. You just go ahead and hold it, keep it close to the vest yourself. Don't explain it to him. And then you say,
you can't do that though, for real, prosecutor. I ain't on nobody's side, but the thing is, you can't hold back evidence. You can't hold back nothing from defense. So they'll know how to work with something. So really, y'all have the information and they got to try to find something to go against y'all, against that information that the state has. So she did do wrong for that. You did do wrong for that, prosecutor.
when it comes up at trial, so what was that? I don't have the report yet. That's why I didn't turn it over to him. It didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation. Okay, so as far as the detective already, and whatever other form he used, that's not coming in.
Okay.
All right, that's the sanction. If you have other information, other discovery that's in the works, you better share it with me. Because right now, if you don't have it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because, you find out they have additional capabilities and you want to go retest something, that's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to him. If you didn't turn it over to him, you can't use it. That's really
right.
basic.
He right about that now, prosecutor. If you got the evidence and you got to turn it over, you got to let them see it. You can't hold it nothing now. See, I knew something when we were with her at the beginning with the prosecutor. I was like, she acting stubborn and selfish, but she can't act like that when somebody's life is involved in a situation. I'm not taking up for Melly, but I'm just saying on the real though. But if she got the evidence, she got to show them too. She can't hold nothing and present it, and they don't know nothing about it. The prosecutor knows she couldn't do that. She playing games. See, I think she wanted to testify.
And so everything has been turned over. That was the only item of which there was additional investigation done on to see if there was any other information or anything else that came out. It was reported to me that it was identical in terms of the information that was done through Gray Key versus Celebrite on that. So defense counsel is attacking the veracity of the Celebrate program on that. So with regards to that, that's the only reason why that would even be brought up. But if I understand your answer, so we can move forward on that. But I do want to address one other issue. More outside the
y'all know what? He always stare at somebody bit in that room. I don't know who he looking at, but y'all pay attention to him in every case. He look at them people in that bag.
Council keeps objecting to publishing of items that are already in evidence and making speaking objections.
Look at him, he
So
ain't
just
looking
asking if
at
the
her.
governor could address that specific issue, because the state can publish the items that are in evidence in the presentation of their case, and defense
looking
can
at
object if
somebody.
there's something that has not been admitted or something to that effect. But in terms of the speaking objections and things like that, those are improper in front of the jury.
Thank you. All right, no speaking objections.
Understood.
When do you expect this documentation to come over?
I think the printer just started working.
And I provided it to, Ms. Liberty.
Do you have those, Ms. Liberty?
Yes,
Yeah, she can't do that. She can't do what she trying to do. She can't do what she want to do. She got to do this fair, and she got to do it right. If she didn't do it right the first time, she messed it up. So she can't present the evidence if they don't know nothing about it. Why are you hiding it from them?